then. Chapman versus American Family Insurance. The appellant and the appellees obviously will have 15 minutes, and appellant may reserve up to 5 for rebuttal. And you know that you have to split your time, right?
Yes,
Okay. Just want to make
there
sure.
may be one issue that I'll let Mr. Johansson address. Maybe he'll go first. I don't know if you want to do it now or
Fill up my reading glasses.
Oh, that's fine.
Which one? I need it.
well,
I did, I shouldn't be here.
Yeah. But we'll wait, I suppose.
Yeah.
That's fine. You just divide it up the way you want to. It's just Mary. I just want to make sure everybody knows you only have this on there.
Sure, thank you.
We'll take 2 maximum. Maybe a minute and a half.
More than welcome to more if you like.
Are they doing a special X-ray or something?
Well,
Yeah, so you can look at my argument over here.
Of course, I left them on my desk anyways.
Oh, no.
That's okay.
You probably have it all memorized.
Absolutely.
All right. You each, like I said, have 15 minutes, and you can reserve for 5 if you want.
Your Honors, if it please the Court, Tom Skidmore, I'm here on behalf of the appellants Kelly and Nicholas Chapman. There's really only one issue before the Court this morning. We would like to probably reserve about 3 minutes for
That's
rebuttal.
fine.
Probably won't take the entire time of the Court, because it's a lot of oral argument. The only real issue before the Court is the lower court's granting summary judgment, deciding that the plaintiff, in this case Kelly Chapman, was not insured under the American Family Insurance policy of the vehicle that she was riding in. So in order to get to that decision, let's take a quick look at the facts of the case that are pertinent. Kelly Chapman is a passenger in a vehicle being driven by a friend, Michael Farmer, November 6th of 2012. She's traveling, and they are traveling westbound on 224, and at that same time and place, I'm going to refer to Charles Scheibel as the tortfeasor in this case. He's traveling eastbound on 224, makes a left turn directly in front of them, causes a pretty severe, violent collision. And Mr. Scheibel is cited for failure to yield and pleads guilty in the Ravenna Municipal Court. That's not me if it's Deformed Summit County, probably shouldn't be Ravenna. The fault of the accident is really not an issue, it's really an insurance coverage issue. Kelly suffered significant injuries. She suffered a orbital fracture to her eye and had some lower limb extremity injuries. Pertinent insurance available in this case is Charles Scheibel. The tortfeasor had liability coverage of $5,100,000. Mr. Scheibel's insurance company was State Farm, and they paid the $50,000 in insurance coverage under the policy. Second insurance available is the Michael Farmer, the vehicle that Kelly Scheibel is a passenger in his vehicle. I'm sorry, Kelly Chapman is a passenger in Michael Farmer's vehicle. He carries through American Family, who's the appellee in this case, a policy of $100,000, $300,000 UIM coverage. Third relevant coverage in the case is Kelly Chapman is listed as a driver and a household resident of an insurance policy of her husband, Nicholas Chapman, which is issued by Progressive Insurance Company. That coverage was $50,000, $100,000. So Scheibel Hood's insurance coverage was exhausted through State Farm. Kelly Chapman then made a policy claim under the American Family Insurance, Mr. Farmer's insurance coverage for $100,000, $300,000. Under the Ohio Revised Code statute, there would be American Family would be entitled to a set-off of $50,000 from the insurance coverage she received from State Farm. So really the amount at issue here is a $50,000 claim from Kelly Chapman to the coverage by Michael Farmer under the American Family Insurance coverage. Mr. Farmer's insurance, American Family, refused to pay on the basis that they believe that although she's a passenger in the vehicle, she is not under the definition of their policy insured. As a result of the denial of the claim, Kelly Chapman filed suit for declaratory judgment, asking that the Summit County Common Police Court declare that she's insured under the American Family policy. And on June 25th of 2015, the lower court ruled that she was not insured under the policy. And from that order of June 25th of 2015, Kelly Chapman then filed this appeal. Applicable to those facts is certain case law. Obviously, the Ohio Revised Code section 393718C is the UIM statute. And under the UIM statute, coverage, quote, the underinsured motorist coverage shall provide protection for insureds thereunder for bodily injury, sickness, and disease. This statute obviously has been subject to a lot of interpretation, a lot of different cases, but the statute clearly says shall provide protection for insureds. So the issue in this case is really whether Kelly Chapman is insured under the policy of Michael Farmer. In determining that, essentially what happens is her coverage through Nicholas Chapman's policy with Progressive, with the set-off, essentially she has no available coverage to her except the Michael Farmer policy. So in looking at available coverage, the Supreme Court in Clark versus Scarpetti decided 91 OS 3rd 271, the Supreme Court held that for the purpose of a set-off, the amounts available for payment language in RC 393718C means the amounts actually accessible and recoverable by an insured or underinsured motorist claimant for all bodily injury liability bonds and insurance policies. And that's the syllabus of the court. So the Supreme Court says that in order, for purposes of the set-off, they use the specific language, quote, amounts available for payment. American Family Insurance in this case is basically stating that she is not insured under their policy because she has insurance available through her husband's policy. But that's not in essence the net effect. With the set-off, Kelly has no available coverage through her own husband's policy. The Supreme Court also said that rather the insurance company could only set off the amount each claimant actually received against the claimant's uninsured policy. The Supreme Court found that for the purpose of set-off, the, quote, amounts available for payment language means the amounts actually accessible to and recoverable by the underinsured motorist claimant for all bodily injury liability bonds and insurance. And that's the Webb case, Webb versus McCarty, 114 Ohio State 3rd, 292, and Luttrell versus Wigglesworth, 91 Ohio State 3rd. That language then is ultimately incorporated almost verbatim into the Ohio UIM statute. And although the Webb and the Luttrell cases were at the time interpreting 393718A2. So essentially, Kelly Chapman has no available coverage through her own policy. And that's essentially American Family saying, you're just simply not insured under our policy because apparently you have insurance through your husband's policy. But she does and she doesn't. You know, she's not able to make any claim.
They're saying she has insurance, and it doesn't really matter whether anything can be paid out. And you're saying it all depends on whether it can be paid out.
That's essentially the crux of the case. So, so American Family denied her claim, saying that she was not a quote insured under, and I'm sure Attorney Hanson will probably argue that under their underinsured motorist statute or their policy language, under additional definitions, it states the following definitions are added. And they say, A, insured person or insured persons means, and of course it's you or your relative, they're talking about Mr. Farmer's policy. And then 2, anyone else occupying your insured vehicle who is not A, named insured or uninsured motorist coverage under another policy. And that's the crux for their denial of the claim, saying she is a named insured under her husband's policy. She's actually, it's kind of a little bit quirky factually, but she's actually not a named insured. She's actually listed as a driver and a resident of the household in his policy. And I guess you'd have to make a determination that that qualifies as being a named insured. After applying the set-off, though, in the case that she really has no other coverage available, and under the American Family Insurance, there's a section F that talks about other insurance. It says other coverage from other sources, and it says, quote, if there is some other similar insurance on a loss covered by this endorsement, we will pay our share according to this policy's portion of the available policy limits of all similar insurance. But, quote, any insurance we provide for use of your insured car by any person other than you will be excess over any other collectible insurance. And so if you read their policy, they start talking about collectible insurance. And in Kelly's case, I would say that the insurance that she has through her husband's policy is not collectible insurance, not available coverage. Under Ohio Revised Code 3937-18C, the statute contains the restriction of limits of coverage available to define the uninsured coverage. American Families basically circumventing the statutory language, changing the definition to exclude those so that they have no coverage available. Such an interpretation appears to be directly contrary to the statute. Based on that particular issue, we would ask that this court declare that she is in fact an insured under policy for the coverage and reverse and remand the case back to the lower court consistent with that.
Thank you.
Thank you.
And you do have 5 minutes remaining.
Your Honors, Counsel, may it please the Court. My name is Jay Hansen. I represent American Family Insurance Company in this matter. At this time, I would believe that Mr. Johansson would like to have 2 minutes after. Yes. As part of my.
That's fine. Thank you.
As part of my argument. The appellee agrees with the statement of facts and the procedural issues as presented by appellant. As far as we see it, this case also revolves around one issue, but it's slightly different than what the appellant frames. We believe the issue is whether the definition of an insured in the American Family Policy is clear and unambiguous. Now, if we look at the trial court's opinion, the trial court had no trouble finding that the policy language in the American Family Policy was unambiguous. In fact, the trial court found by the unambiguous terms of the American Family Policy, plaintiff is not an insured person. Now, the portion of the policy that we're looking at here today indicates, and Mr. Skidmore has already read it, but I think it's worth revisiting. Insured person or insured persons means you or a relative, anyone else occupying your insured car who is not a named insured for underinsured motorist coverage under another policy, a self-insurance program, or liability bond. I don't think that there's any issue that Ms. Chapman was not a relative of Mr. Farmer. So we need to look at number 2. I don't think there's any issue there either that Ms. Chapman was insured under a policy of insurance with Progressive Insurance Company. Based on that alone, she does not meet the definition of an insured for underinsured motorist coverage purposes under the American Family Policy. That leads us to this central issue of whether or not this portion of the policy is unambiguous. Again, the trial court found that. And then it also leads us to the question of whether or not an insurance company is permitted to define an insured the way it wants to. The Ohio Supreme Court has unequivocally said that an insurer issuing an automobile policy may define the class of persons who qualify as insureds under that policy. In Wool versus Swinney, the Ohio Supreme Court determined that an insurer may restrictively define who qualifies as an insured under a portion of a policy to exclude passengers who have their own coverage. And the Ohio Supreme Court, in that case, held that there is nothing ambiguous about an insurance policy definition for uninsured motorist coverage that specifically defined an insured as any other person occupying your covered auto who is not a named insured or insured family member for uninsured motorist coverage under another policy. That is language very, very similar to the language in the American Family Policy. So we submit to this court that the Ohio Supreme Court has already ruled on this issue, saying that there is nothing ambiguous about the language in the American Family Policy. Further, the Ohio Supreme Court has also found in Holloman, in Holloman versus Allstate Insurance Company, that nothing in Revised Code 393718 prohibits the parties to an insurance contract from defining who is an insured person under that policy. Now, appellant cites to 393718 in his argument and in his brief. I have read, reread, triple read, I have read many times 393718 in this case and can find nowhere where 3937 requires an insurance company to define an insured as the appellant would have it. Interestingly, there is a very similar case to this one, a Cuyahoga County case, be it Johns versus Hopkins, virtually identical facts, and that is outlined in my brief. And basically the court said that the insurance company there could define who they want to be an insured under the contract. While it may be unfortunate here that the appellant is not an insured under the American Family Policy and has no other source of recovery for the injury she claims from the accident, the American Family Policy unambiguously excludes coverage for her in this case. Frankly, we have to look at whether that policy is unambiguous or ambiguous. We submit that based on other language in other cases, the American Family Policy language is virtually identical, which has been found to be ambiguous and valid. American Family, therefore, requested the ruling of the trial court finding that there is no coverage for the appellant under the American Family Policy be affirmed. Thank you.
Thank you. You may.
Thank you. May it please the court, Mike Johansson, I represent Progressive. In the trial court, Progressive was joined by American Family by way of a third-party complaint, not sued by the plaintiff. Progressive secured a summary judgment based upon the set-off provisions, which are not disputed. The the order granting summary judgment in favor of Progressive was not appealed from. I don't think I should even be here as part of this appeal, but it was somewhat unclear given the circumstances of the case. But no one has mentioned anything today about set-off that being invalid or any other reason that the cause of action should lie against Progressive. Thank you.
You do have 5 minutes.
Thank you, Your Honor. I really don't have any rebuttal. I think both sides have already represented their arguments. I just point out that Johns versus Hopkins case that was pointed out by American Family happens to be a 2-to-1 court decision, which if you review...
Happens to be what?
A 2-to-1 decision, not applicable in this district, and also in reading the dissenting opinion in that case, and even the concurring opinion is a little odd, where the court recognizes that there's this struggle with this particular issue. So it appeared to be a very close call in that case, and the concurring swing vote in that case seemed to be very reluctant to do so.
Your opposing counsel says the Supreme Court has spoken on this issue.
I haven't seen that case on this particular fact.
Yeah, it may have been maybe in this statement, maybe it was the Court of Appeals.
In Wohl versus Swinney, I believe that was in Ohio Supreme Court.
And is it in your brief?
So.
That's okay. We'll look.
Okay. All right. And if it was,
just double check that and see what your rebuttal was.
I don't recall a specific Supreme Court case involving this particular issue. In looking at the UIM statute and the mandatory offerings of UIM appear to be very relevant to me in this particular circumstance.
Well, I appreciate it. Thank you to both sides. We will take the matter under advisement and issue a written opinion that will be sent to both of you and to all three of you, obviously. and the court also releases them on our website, so thank you.
Thank you.
And the court will be adjourned until